Welcome to the Lowenstein Sandler podcast series. I'm Linda Bennett, chair of the Insurance Recovery Group at Lowenstein Sandler. Before we begin, please take a moment to subscribe to our podcast series at lowenstein.com/podcast or find us on Amazon Music, Apple Podcasts, Audible, iHeartRadio, Spotify, SoundCloud, or YouTube. Now, let's take a listen.
Welcome to Don't Take No for an Answer. I'm your host, Eric Jesse from Lowenstein Sandler's Insurance Recovery Group. And today I'm pleased to be joined by Mike Young, who's a partner at Reichardt Noce and Young, along with my colleague, Heather Weaver, who's counsel in Lowenstein's Insurance Recovery Group. So Mike works on the other side of coverage cases. He represents insurers at all stages of the claims process, including litigation. And Heather and Mike recently spoke on a panel together at the American Bar Association's 49th Annual TIPS Conference on a very important but lesser discussed topic, which is the insurer's duty to indemnify. So much of the discussion is typically focused on the insurer's broad duty to defend because that obligation will arise once there's an allegation against the insured that can potentially trigger the scope of the insurance policy and the coverage. But today we're going to dive into a discussion on indemnity, a lesser discussed but very important coverage obligation that both insurers and policyholders should be thinking about early on in the claim process. So with that, Mike, why don't you set the table for our loyal listeners here and talk at a high level and explain what the insurer's duty to indemnify is and how it differs from the duty to defend.
Sure. Happy to do that. And Eric, Heather, thanks for having me on the podcast. I think it's an important topic because we spend so much time, as you indicated, Eric, trying to figure out, does the insurance company have a duty to defend, which is essentially the insurance company paying to hire a lawyer to defend the insured in a liability claim. But we don't often think about, maybe until the end, does the insurance company have a duty to indemnify, which is essentially, does the insurance company under the liability policy have an obligation to pay a judgment or settlement that might be entered against the insured? And I joked at the conference, Heather, we say all the time, the duty to defend is broader than the duty to indemnify. If you hadn't heard that before, you're probably need to go to the Amway conference next door. And I think you're in the wrong room. We say that all the time, but what does that mean? Right. And so the duty to defend in most places is determined by looking the allegations in the complaint and trying to see if you accept all those as true, does the claim fall within the scope of the insurance policy? Some states, maybe even a majority of them, will also allow consideration of materials outside of the complaint, extrinsic evidence sometimes, to also, as a duty to defend, created or maybe even taken away by that extrinsic evidence. But what about the duty to indemnify? That's the important one, because that's where it comes down to. Is the insurance going to pay to settle this case? And if so, how much? It really kind of turns on that. And when you look at cases in different states, there's not nearly as much case law on this. Sometimes in some jurisdictions, there's literally a handful of cases and the rules can vary kind of wildly on it. But at the end of the day, the duty to indemnify in its simplest form, you're looking at sort of the actual facts. Or we're not accepting everything in the complaint as true, but like actual evidence, whatever that is the lawsuit actually covered by the insurance policy? If so, the insurance company may have a duty to pay for a judgment or settlement that's entered under those actual facts.
Yeah, I think you laid it out perfectly, Mike. And I agree. I mean, that really is that key distinction where the duty to defend, right? You're looking at the allegations that are made against the insured versus, all right, now there's a settlement, there's a judgment that comes up, and now the insured and insured join issue on, right, what is the actual evidence that does trigger coverage? And you're right. We've been looking into this issue and litigating this issue too on our various cases. And I agree with you. I mean, there's plenty of case law on the duty to defend, but when it comes to the duty to indemnify, it's certainly not as litigated as much, but it's an issue that certainly is coming up because as policyholders, we're certainly looking for insurers to help fund or entirely fund, settlements and judgments. So.
It's really, and a lot of times the claimants will plead certain things and complaints to trigger duty to defend, which is fine. But then it comes mediation time or trial time. And they're like, okay, now we want you to pay for this too. And I'm like, well, not so fast. I understand what you pleaded to get us into the ball game, but like, what's the reality here? Is it actually covered or
Yeah, absolutely. And so we're always trying to obviously work towards getting that contribution and making sure we can establish that, because part of this is just also having that open communication where we can just work productively together. Heather, why don't you just kind of give us a little bit of an overview of how an insurer's breach of its duty to defend could impact the duty to indemnify?
Sure. So the breach of an insurer's duty to defend could have a huge impact on its duty to indemnify. And it's important for policyholders to understand what they might be entitled to in the event that their insurer breaches the duty to defend, or even worse, acts in bad faith. As Mike mentioned, the law does vary by jurisdiction, which is one reason why it's important to consult counsel on these issues. But in at least some jurisdictions, including New Jersey, an insurer that breaches its duty to defend risks liability not only for payment of those defense costs, but also potentially for an indemnity payment for an underlying judgment or a verdict or a settlement. And also in New Jersey and in some other states, they also risk having to reimburse coverage counsel fees to the policyholder in connection with bringing a lawsuit to pursue coverage. And this type of fee shifting in a situation where the insured is forced to bring a coverage action to enforce its rights under a policy and is successful in doing so, it can be a substantial and unnecessary added expense for an insurer, and essentially can become a situation where an insurer is essentially fighting with itself, racking up coverage counsel fees for both sides. And it's obviously a valuable form of recourse for policyholders in states that have this type of fee shifting law. And so as a policyholder, it's important to understand whether that's something that might be available to you.
Yeah. And Heather, you touched on it, and Mike also touched on it, which is just the choice of law piece, because we're speaking in generalities here, but certainly the choice of law matters. That's certainly a theme of ours here on Don't Take No for an Answer. And we certainly, as policyholders, we do like to be in jurisdictions that will give us some fee shifting leverage as we're trying to bring an underlying claim to resolution. So absolutely. Mike, what are some things that, from your perspective, that insurers can be doing in order to avoid a coverage breach and the potential consequences of that?
Yeah, I think it sort of depends on what jurisdiction you're talking about.
Yeah.
If you're in one like Heather was describing, where if the insurance company breaches its duty to defend, it doesn't provide defense counsel when it was supposed to. If you're in a state that says that means estoppel or whatever theory applies, and now you automatically have a duty to indemnify whatever happens later, boy, if you breach that duty to defend, it's catastrophic, right? So if you're in one of those kind of jurisdictions, it's sort of like, okay, guys, if we're going to decline this, we better be right. Because if we're not, we have a lot of bad stuff that's going to happen to us. So in those places, I think, insurance companies may provide defense under reservation, at least in cases where maybe they wouldn't in other jurisdictions. If you're looking at a place maybe more like where I am in Missouri, maybe Illinois, where the breach of duty to defend doesn't necessarily mean de facto you have a duty to indemnify, then you're looking at other things. It's almost as if, okay, we breached the duty to defend. That means we're liable for defense costs, but we still have the question, is there a duty to indemnify that judgment or settlement? And then you're doing sort of the same things that you might do in a state where we have to defend. Otherwise, there's estoppel. So you're looking at, I know we'll talk about this, the evidence as it proceeds in the case, what's presented to the jury, what facts are in the judgments. Do we have consent judgments? So you're looking at those kind of things too. I think there are some states also that, and maybe Illinois is one of these, that even if you don't defend when maybe you should, if you file a declaratory judgment action, that can somehow toll the estoppel doctrine from applying. And if a court says, well, you did have a duty to defend, so be it. Okay, now we owe the defense cost, but we're still now look at these actual facts. It's not like, oh, you didn't defend, now you go to jail sort of thing. Like I said, it just depends, in my view, so much on what state you're looking at.
You're absolutely right, Mike. I've just seen this issue come up recently because you've been mentioning Illinois, where we have a client, the underlying case in Illinois, and the insurer denied coverage. And I get the call saying, all right, now we think we have to sue you, file a declaratory judgment action against your client. And we don't really want to do that. So maybe we can enter into some sort of tolling arrangement. along the way. So again, I think that's a little unusual in my experience, although I'm based here in New Jersey. But yeah, it could certainly run the gamut as you described there.
Well, it's such a nuance on Illinois because I'm in St. Louis, I'm in Missouri. Most of my coverage work is in Missouri, but I have at least as much coverage litigation in Illinois just because of that rule.
Yeah, I have a case, Mike, in New Jersey. As you mentioned, the procedure by which an insurance company breaches or withdraws its defense could have a huge impact. So I had a case, for example, where the insurer agreed it had a duty to defend it, and then instead of filing a declaratory judgment action, just pulled the defense. And this was right before mediation in the underlying action, and said, policyholder, you're on your own. We're pulling the defense, didn't file declaratory judgment action to have their rights and obligations under the policy litigated. And so there were consequences for the insurer in that situation because they just didn't do it the right way, and they left the policyholder in a bind.
Right. In New Jersey, correct me if I'm wrong, Heather, doesn't have some nuance too on the duty to defend, where maybe the carrier only has to defend covered counts versus uncovered counts. And that's very, very different than my experience almost everywhere else.
Yeah. And there, when we get those arguments, Mike, what we try and do is there's case law in New Jersey that we'll rely on that says, all right, yeah, but when defense counsel's going to the deposition, right, you can't break the deposition down between the various causes of action. So when defense counsel's there, they're there to defend the entire case. And so if their work benefits both a covered and uncovered claim, then we would certainly advocate that all of those amounts would be covered. But yeah, that
it's sort of like when you're sitting there defending that, it's like, well, that's a count 5 question. I guess I don't have to object to that one.
Exactly. The courts are not going to require there's more of the practical rule here. Right? Defense counsel shows up for that deposition. They're obviously there to defend a covered claim. So we would try and allocate those costs entirely to the insurer. And argument was, it is, and we believe the law is that, the insurer would have the burden to show that a particular task was exclusively for an uncovered cause of action. So if it's research regarding cause of action, the first count of the complaint, and that's the one that's not covered, then all right, then maybe there's an argument there for the insurer to allocate that cost to the insured.
Got it. I guess finally answer your question, Eric. Insurance companies can consider settling cases in order to prevent, if there's any issues with the failure to defend what we should.
Mm-hmm.
That's always an option as well.
Yeah, absolutely. And that's also kind of just music to our ears as coverage counsel, where we do want insurers involved in settlement, even if they're anticipating a denial. If there's a way that we can, work practically together to just bring the whole thing to resolution, that can usually benefit everyone. So.
Yeah, absolutely. I mean, at the end of the day, I think the policyholder and the insurer share a common goal there, right? Resolving claims efficiently, avoiding costly litigation for both sides, preserving resources, maintaining positive business relationships. And just on the policyholder side, we make sure that we openly communicate with the insurers throughout the litigation, which allows both sides to stay on the same page, make informed decisions together regarding potential settlements. And it's always best when there's no surprises, and keeping everybody in the loop throughout the litigation seems to be the most effective way to do that.
Right. Because all this stuff is expensive, right? Paying for, although our rates are certainly affordable and reasonable. But at the end of the day, we're paying all these different people, defense counsel, coverage counsel. Maybe we have to pay you guys if it goes wrong. Isn't settling some of these things, does it make some sense? The other piece of it, and I've seen too, is maybe an insurance company gets the complaint in. Part of their defense analysis, we may just provide a defense without reservation because we think this insured has a really good liability defense. They're going to win this case 8 out of 9 times, whatever.
Yeah.
Do we really want to go and have a civil war on coverage with everyone if it's debatable, when at the end of the day, if we just defend this thing, we're going to win and close the case out? So there's all kinds, I think, considerations that go into that.
Yeah. And the settlement piece, obviously, that's where most often we see that duty to indemnify coming into play. I mean, Heather, I think you touched on it, where just communication is key, because a lot of times litigation is going to move at its own speed. And obviously, we want the insurers to keep pace. But, if we can all just recognize, all right, there's going to be a mediation on this date. We understand that the insurers have to do their own due diligence there. They're going to have questions. So where we can get the necessary and reasonable amount of information over to the insurer so that they can be able to participate meaningfully in a settlement opportunity. That's where I think just having those open lines of communication can be very helpful, as opposed to, oh, hi, there's a mediation tomorrow. So.
Yeah, and that's right. And from a practical perspective, because that does happen sometimes, right? Where insurance companies find out about mediations 2 days ahead of time, 3 or 4 days ahead of time.
Yeah.
Particularly when there's independent counsel defending the case. Those are really difficult for the insurance company to get its ducks in a row, to get their authority together in order to go to a mediation and really meaningfully participate. So I agree. The sooner that the insurance company is notified of that stuff, then there's no excuse.
Yeah, no, in that perfect world, absolutely. This has been a great discussion. Maybe we can just bring it home with one last question here, Mike. Just from the insurer perspective here, how closely are you monitoring the factual and legal findings in the underlying case when you're just assessing that ultimate duty to indemnify obligation?
Hardly ever. No, I'm just kidding.
All right, the cat's out of the bag.
That's right. We paid no attention to that whatsoever. We're obviously looking at that all the time, particularly if you're in a state where, like, how do we determine these actual facts? If we're in a state where if a case goes to trial and there's jury instructions with factual findings that are relevant to coverage, boy, are we looking at that. And then also, are we bound by those? Does collateral estoppel apply in those situations? Again, so state dependent. But in places like, for example, my state of Missouri, we have strict rules on jury instructions. You're usually not going to get a finding by the jury or trier of fact on anything relevant to coverage. And so now we're looking at the evidence that's developed during the case. So what's said in these depositions? What are in those interrogatory answers? And then if cases go to trial, what kind of evidence is presented to the jury? Because even though the finder of fact may not determine anything on those facts, in a lot of states, that evidence presented may be the universe of evidence that in a subsequent coverage case, we're going to figure out what those actual facts are. What is the evidence? And so depending on the case and the value, so forth, we may actually, coverage counsel, we're not defending the case, but we may sit in the back of the group just so we can sit here and watch all this and see what people are saying. And so we can assess, oh, this is more likely covered than not, right? And so maybe that may affect those settlements on the jury's coming back. Do we take care of this before they give us their ultimate answer? Because we know what that evidence is. And then also some places, once you look at stuff outside of that trial evidence to figure out, if there's a duty to defend. You see that a lot in construction cases on timing issues. Sometimes the subsequent coverage case on when was the work done or when did the damage occur? Do we have a continuous trigger? All those things that we find so interesting are all based on facts. And, do we have to hire experts on top of that? So now we can have trial number 2 to figure out if we have to pay for trial number 1. So all that stuff is super important. And yet, if we're going to mediate a case, we need to know what that is, before we walk in there to see what is our indemnity position.
Yeah, no, absolutely. Yeah, you described kind of like the scenario we never like to see, which is, all right, we just tried the underlying case and all right, now we're going to have to go try a coverage case to figure out, to fill in the gaps on those facts, which is just a proposition that policyholders just don't want to deal with. So, but yes, that can be the reality sometimes.
And I think too, honestly, it's not a scenario that insurance companies want either.
Yeah.
Because we're doing the same thing. We're litigating with you guys, debating what happened a year and a half ago at that trial.
Great. This was a great discussion. I'm sorry to have missed out on the TIPS conference because just from listening to you two, I know that it was a great panel discussion that you all had. So Mike, thank you so much for joining us. And Heather, thank you for also coming on Don't Take No for an Answer.
Happy to be here. Thanks, Mike.
Absolutely. Thanks for having me.
Thank you for listening to today's episode. Please subscribe to our podcast series at lowenstein.com/podcast, or find us on Amazon Music, Apple Podcasts, Audible, iHeartRadio, Spotify, SoundCloud, or YouTube. Lowenstein Sandler podcast series is presented by Lowenstein Sandler and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of counsel. Prior results do not guarantee a similar outcome. Content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.